you all hear me? Okay, we're going to go ahead and get started. I wanted to welcome y'all out today. Good afternoon. My name is Kelsey Flores. I'm the president of the Federalist Society. This event's really exciting. It's co-sponsored both by the American Constitution Society, ACS, and the Federalist Society. And the goal of both of these organizations is to create debate, to encourage discussion, kind of to provide a forum to talk about important and relevant topics. Sometimes in law school we don't get to talk about the stuff that's really timely. So this is why we put on these kinds of events. Today we're really fortunate to have two distinguished speakers that are both. Is there a lot of feedback? Is that better? Okay. Today we're going to have two distinguished speakers. We're going to introduce them a little bit more later. But what's neat about them is that they're both experts in constitutional law. And so really distinguished and qualified to be here talking to us today about the Second Amendment. The name of this event is it's Gun Rights and School Safety, the Second Amendment after Parkland. And it's just the March for Our Lives so recent. This is a really timely topic, like we mentioned beforehand. We're going to have Professor Josh Blackman speak, and we will also be hearing from appellate attorney Jason Steed. We're really grateful to have them both, and our very own dear Professor Taylor will be moderating, and he teaches both contracts and patent law here. In terms of format, so y'all kind of know what to expect. As soon as I'm done, and I'm almost done, I'm going to turn the time over to Dominic Cruciani, the Vice President of the Federalist Society. He'll give us a quick bio on both of the speakers, and then we'll turn the time over to Professor Taylor, who will be moderating the event, and then our speakers will start debating about this really timely event as well. And then at the very end, if you're thinking of questions that you want to be asking, we'll have time reserved at the end for Q&A, so you can ask either of those for debate. And I will now turn the time over to Dominic Cruciani.
Well, thank you, Kelsey, and thank everyone for being here. We have a really great turnout, so glad to see people are excited about this debate. As Kelsey said, we're very fortunate to have two very distinguished speakers here. On your right, we have Professor Josh Blackman. He's a graduate of George Mason University School of Law. After he graduated, he clerked for both the Honorable Danny Boggs of the Sixth Circuit Court of Appeals and Honorable Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. Professor Blackman is an associate professor at the South Texas College of Law in Houston, where he specializes in constitutional law, the Supreme Court, in the intersection of law and technology. Last month at the FedSoc National Student Symposium, got to give him a shout out. Professor Blackman won the Paul M. Bader Award, and during his reception, he was described as a force of nature who never stops learning. So we're very fortunate to have him. He was also selected for the Forbes magazine 30 Under 30 for law and policy, in addition to his professor and award-winning performances. He's also an accomplished writer and scholar. He's authored 2 books, written over 40 law review articles, which is unimaginable me after doing 2. Yeah, including the Harvard and Texas Law Reviews. He's appeared on several major news networks, including New York Times, Wall Street Journal, Washington Post, many others. And lastly, he's the founder and president of the Harlan Institute, which is an organization focused on bringing the Socratic stylized law school experience to high school classrooms to ensure that students understand the significance of the Constitution and the Supreme Court. And then in the middle, turning to our next speaker, we have Jason Steed. He has a great academic pedigree. He holds 4 degrees, including a PhD from the University of Nevada, Las Vegas, a Master of Fine Arts from the University of Idaho, and a JD from the University of Texas School of Law. During law school, he was on the editor's board for the Texas Journal on Civil Liberties and Civil Rights, and president of the American Constitutional Society. He remains active with ACS and sits on the advisory board for the DFW Lawyers chapter. He's counsel at Kilpatrick Townsend, where he's an appellate attorney practicing in complex commercial litigation, class action, constitutional law, many other practice areas. He's been described in a federal judge's written opinion as an excellent lawyer who provides rigorous, high-quality representation, so we could all hope to get such a shout-out from a federal judge. And lastly, he's a former English professor and an award-winning writer. He regularly publishes and presents on the Supreme Court, legal writing, and appellate practice. He's also very active on Twitter, where he's a contributor on the hashtag appellate Twitter community. So Please join me in welcoming our speakers. Turn it over to Professor Taylor, our moderator.
Thanks, Dominic, and thank you to the Federalist Society and the ACS for sponsoring this event, in particular to Kelsey Flores, Andrew Gray, and Dominic Cruciani. We come together today to hear and engage in a debate regarding how the Second Amendment limits the ability of federal, state, and local authorities to respond to gun violence in schools. And I'm just going to give you a update on recent events. You guys know this, but just to set the stage for our speakers, gun violence in schools has garnered significant recent attention. On February 14th of this year, as we all know, 17 students, teachers, and coaches were killed at Marjorie Stoneman Douglas High School in Parkland, Florida, shot to death by a 19-year-old former student with a semi-automatic rifle. While there are many other examples of gun violence in schools, perhaps the most notorious are the shootings at Sandy Hook Elementary School in Newtown, Connecticut in 2012. 28 were killed there. And at Columbine High School in Littleton, Colorado in 1999, 15 killed there. In light of the most recent shooting in Florida, though, various groups and people have proposed different types of reform. Most recently, I think, former United States Supreme Court Justice John Paul Stevens wrote in the New York Times that the Second Amendment ought to be repealed. He referred to the Second Amendment as a relic of the 18th century and said that its repeal would, quote, do more to weaken the NRA's ability to stymie legislative debate and block constructive gun control legislation than any other available option, close quote. For today, however, we set aside that proposal and instead focus on how the Second Amendment, as interpreted by the Supreme Court and the lower courts, limit the ability to implement proposed legislation and regulatory reforms. Let me give you just a brief outline of current proposals, some already enacted. Increasing the rigor in background checks as a prerequisite for gun purchases, including what's called the Fix NICS Act, which penalizes government agencies for not reporting information to the National Instant Criminal Background Check System, that's NICS. A ban on so-called bump stocks, devices that cause semi-automatic rifles to fire more rapidly, causing them to act more like automatic weapons. Raising the age to buy a rifle from 18 to 21. Arming teachers and school personnel. Banning semi-automatic weapons, and there are many other proposals out there. Some of these proposals, like I said, have already been enacted. And let me just get you up to date. On March 9th of this year, so less than a month ago, Florida enacted the Marjorie Stoneman Douglas High School Public Safety Act. Among other things, this act creates risk protection orders, which allow courts to prohibit a violent or mentally ill individual from purchasing a firearm or other weapon, with some exceptions. It raises the age to purchase firearms to a minimum of 21 years. It bans the sale or possession of bump stocks, and creates a 3-day waiting period for all firearm sales. So that's in the state realm. On the federal level, on March 23rd, so about 2 weeks ago, President Trump signed into law the Fix NICS Act, and that's what I just described earlier. So there's a lot going on here, an important issue. And with that background, let me ask Professor Blackman, who agreed to start our debate, to go ahead and give us his presentation.
Yeah, thank you. Thank you very much, SMU. It's a pleasure to be back here. Hello there. I see you're all eating burritos. I can't eat a burrito because it's Passover. But one thing about Passover that we all know is there's a question. There actually are 4 questions. The question that's always asked is, why is this night different from all other nights? So I want to pose a similar question to you. Why is this right different from all other rights? Why is the Second Amendment different from other rights? I'll argue it's actually not very different. In D.C. v. Heller and McDonald v. Chicago, which are the big Second Amendment cases, the majority and the dissent differed over the pedigree and history of this right to bear arms. But they agreed that the governmental interest in reducing risk of danger should play some role in this constitutional calculus. So the question is, how do we compare the Second Amendment to other rights in our Constitution? So at first blush, they say, wait a minute, Josh, guns are dangerous, right? Justice Breyer said that, quote, the carrying of arms often puts other lives at risk. And he said, because a primary concern of every government is a concern for the safety and indeed the lives of its citizens, he says, we should consider how dangerous, what you might call the social cost of guns is, when we're regulating them. Now, this is an obvious fact, But it's so obvious we don't consider how other rights in the Second Amendment also have what we can call social cost. If you want to do an economics, externalities. So let me walk you through a few of these examples. The right to speak freely is balanced with the possible harm that can yield from people preaching hate, violence, intolerance, and even fomenting revolution. The freedom of the press permits the media to report on matters that may harm national security. The freedom of association allows people to congregate to advocate for certain types of violence. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures enables the possessions and the fruits of crimes to exist with impunity. Inculpatory evidence seized in violation of this right is generally inadmissible. This is what's called the exclusionary rule. This allows some crimes to go unpunished. Likewise, a violation of a person's Miranda rights renders certain confessions, even an uncoerced confession, inadmissible. Procedural rights during trials, including the right to a grand jury indictment, the right against self-incrimination, the right against double jeopardy, the right of compulsory process, the right of confrontation, the right of a speedy and public trial, and the right of trial by jury, all make the prosecution of culpable defendants significantly harder. The Due Process Clause, which imposes limitations on all government action, places the burden of proof beyond a reasonable doubt, not on the defendant, but on the prosecution. The right to non-excessive bail and reasonable fine makes it easier for suspects to avoid prison during prosecutions and may allow them to abscond before trial. The right against cruel and unusual punishment removes certain forms of retribution from the quiver of the state, thereby limiting the range of punishments for those found guilty of a crime. The right of habeas corpus ensures that a person, however dangerous, cannot be detained indefinitely without proper procedures. Liberty is harm to society can take many forms, not just from the right to keep and bear arms. These precedents illustrate how the court balances freedom and the harm that results from its exercise. Although a primary concern of every government is a concern for the safety and the lives of its citizens, this concern is not constitutionally sacrosanct. So I think Jason and I will probably agree on quite a bit, right? I am fully cognizant that the courts haven't treated the Second Amendment as an absolute right. We can just dispense with that already. Because the Second Amendment is not absolute. Okay, yeah, we got that. That takes 5 seconds. The harder question is what you do when you get beyond that initial bromide, right? So my approach, and I wrote this in a paper some years ago, looks at what we call the social cost of liberty. Now, some courts have said we can look to the First Amendment to understand how guns should be interpreted. I prefer a more holistic approach. And if you walk through the entire Bill of Rights, which I was due to a moment ago, first, second, third, fourth, all the way down to the Eighth Amendment, you see the court has different precedents for balancing a state's interest in safety and a state's interest in promoting individual liberty. Respectfully, I think this inquiry is probably more helpful than asking whether something is the core of the Second Amendment or the number of the Second Amendment or any such inquiry that really courts don't really care much about. So I don't know how courts will interpret the Second Amendment following this most recent attack in Florida or other attacks that have happened in recent years. But I want to put the Second Amendment in perhaps a different light than what others have done. And the basis of this frame is a threat, right? When there's a threat that's imminent, the court permits greater infringement on individual liberty with minimal, if any, judicial oversight. You might remember from criminal procedure that if, let's say, the police suspect someone has a bomb, there are exceptions to Miranda, right? There are exceptions to the search and seize rule. You got to disarm the guy right away. There's exigent circumstances, right? But second, when a threat is not yet imminent, but a person's previous misconduct reveals a propensity towards future violence, the courts do permit an infringement of individual liberties, but they mandate some form of judicial oversight. Okay? Third, when there's a threat that's cognizable, but not necessarily imminent, right? Infringements are permitted, but with greater judicial scrutiny. However, when the threat is neither cognizable nor imminent, and when the actor has no propensity for danger, but the proposed harm is predicted purely on some sort of speculative assessment, and what may or may not happen. You can't restrict the freedom in the absence of some evidence. This is an important point. Burdens, right? Some of you will be litigators one day. Jason's an excellent litigator, and I'm sure he'll tell you, if you're in court and you have the burden, you're in a tough spot. If the burden's on the other side, you're in a much better position. And invariably, in the very Second Amendment cases that have come before the court, the burden is almost always on the challenger. That is, the person asserting, why do I have to exercise this right? Why do I need this gun? Why do I need this type of magazine? That gets it backwards. Because in most cases where a right's being infringed, the burden is on the state. Why am I taking this away from you? Why can you not own this? The courts have very quietly reversed this presumption, what you might call constitutionality for reparative products, and they put the burden on the individual rather than on the state. So my approach would in large measure ask a couple different questions, right? So first, does the person applying for this right have some sort of propensity for violence? This can be shown based on a criminal background, or perhaps any sort of restraining orders taken out against him, mentioned earlier, or various other indicia, okay? But when you have a person who lacks these propensities for violence, the burden to deprive the right must remain with the state. If you have this propensity for violence, you, the individual, have the burden to show why you need to exercise this right. Now, all of this is all well and good, and I'm sure we want to talk about specific proposals. So what I want to do next is walk you through various lower court decisions, okay, involving how the circuit courts have interpreted the Second Amendment. Jason and I will agree at this point too. Since 2010, when the court decided Heller, the court has been basically hands-off on guns. They have not been interested. They had one brief per curiam opinion about stun gun on the old Zapper things, right? But they've taken it away. So in the absence of any sort of Supreme Court intervention, the lower courts have basically been on their own. And the courts have read the Second Amendment in a very narrow function. The only person on the Supreme Court who shows any interest in enforcing these regimes is Justice Thomas. And Justice Thomas has issued a note of dissent from denial certiorari saying, what are you guys doing? And Justice Thomas has actually asserted that the majority is treating the Second Amendment as a second-class right. So let me walk you through some of these opinions. So for example, one, there's a San Francisco law that required a handgun must be locked at all times at home. Okay? I don't know if you ever tried to find your glasses or unlock your iPhone at night, but it's often very difficult. Having a lock provision makes it very tough to actually get it done out at night. This actually came up in an argument in Heller. I think it was Justice Roberts asked Walter Dellinger, a lawyer, have you ever tried, maybe it was Scalia, have you ever tried to open a gun lock at night with your glasses off? And he basically had to futz and fumble. But the answer is you really can't. They're very hard to open. But San Francisco makes you lock up your guns basically at all times when you're at home. The Ninth Circuit upheld this practice. The Supreme Court denied certiorari. Justice Thomas and Scalia dissented. And Justice Thomas wrote, despite the clarity with which we describe the Second Amendment's protection for the right of self-defense, lower courts have failed to protect it. He said, Second Amendment rights are no less protected by our Constitution than other rights enumerated in the document. Okay? Then we have another case, Highland Park, Illinois. Highland Park instituted what's called an assault weapon ban. Now, most law students don't know what an assault weapon is. They think it's this big, scary machine gun you see again. The actual definition of assault weapon refers to cosmetic features, right? Almost all rifles are semi-automatic because when you pull the trigger once, one bullet comes out. If you pull the trigger once and it sprays, that's called an automatic weapon, and those have been heavily regulated for decades. I'm not even talking about those. A semi-automatic rifle, you pull the trigger once and one bullet comes out. What's the difference between a rifle and an assault weapon? Cosmetic features. So for example, if you have a little grip in the front, which doesn't change the firepower or the accuracy of the weapon, that's a feature. If you have a little rest to put in your shoulder so you can lean the gun against your shoulder, that's a feature. If it has those features in the gun, it becomes an assault weapon. That's something that's bad. It in no way affects the speed or velocity or lethality of any of these weapons. My favorite one is it has a grenade launcher on the front of the gun becomes an assault weapon. I've never seen these in my entire life, but these are the things they define. A bayonet law, right? If you want to take out some militiamen in Boston, right? You put a bayonet on front of your head. That's one of the features. Okay? So Highland Park criminalized the possession of so-called assault weapons. The Seventh Circuit upheld these laws, and again, the Supreme Court denied review. Justice Thomas once again issued a dissent, and he wrote, "The Court of Appeals explained that even if the law didn't actually improve safety, the law was valid because it may increase the public's sense of safety." In other words, it gave them the feels, right? It made people feel good. Justice Thomas dismissed this reasoning. He said the broad ban on firearms can be upheld because the conjecture that the public might feel safer, while not being safer at all, and the Second Amendment guarantees nothing. I'll get to assault weapons probably a little bit later in the talk, but he's right. The overwhelming majority of gun deaths are not from assault weapons, they're from handguns. Over 90%, very few assault weapons are used in these sorts of events. But again, Justice Thomas was only alone in dissenting. After Justice Scalia passed away, we had another case come up called Peruta versus California. This is a case involving the right to keep and bear arms outside the home. Virtually every state in the country allows people to carry outside the home with a license. But the regimes of how to get such a license vary wildly. And there are two types of laws. Texas is what's called a shall issue, right? If you apply for a handgun license, a concealed carry license, and you have no criminal background issues, the government is required to give you a permit to carry. Other states, for example, California, have what's called a may issue. That is, even if you're like a nun, your sister Jean, right? And you apply, too soon? You apply for a handgun license. You've never done it in your life, you're a saint. Unless you can show a compelling need of why you need that license, you don't get it. And as this works in practice, who gets it? The rich and the powerful, right? If you're a celebrity in Hollywood, you'll get your permit. You'll be friends with the sheriff. But you know, the single mom who needs to walk home from the bus at night, she's probably out of luck. So these are how these laws actually work. They're purely discretionary who can actually get these permits. In California, it's actually rampant of how they're used in discriminatory fashion. You don't like giving government discretion. This is a very big aspect of discretion. Yet the Supreme Court denied review of the Ninth Circuit's decision. Justice Thomas issued a dissent and joined by Justice Gorsuch. And he had this one line, which I want to read to you. He said, "For those of us who work in marbled halls, guarded constantly by a vigilant and dedicated police force, the guarantees of the Second Amendment might seem antiquated and superfluous. But the framers made a clear choice. They reserved to all Americans the right to bear arms for self-defense. I do not think we should stand by idly while a state denies its citizens that right, particularly when their very lives may depend on it. I dissent." Okay. One more case, and I'll move on to the more current events. There was a decision a few weeks ago where California, again, enacted a policy imposing a 10-day waiting period. Now, you may say, well, what's the big deal, 10-day waiting period? This applies to even people who already have guns, if people already passed the background check. And they said, well, look, I already passed the background check, I've been clean, I have a license, I'm up to date. Why do I need to wait 10 days? And it makes you feel safer, right? Court, Ninth Circuit upheld the law, the Supreme Court denied certiorari. Justice Thomas issued a dissent, was it 2 days after the shooting in Florida? Maybe 3 days after? I think it was the following Monday. Gorsuch did not join that one, and I did note that, Justice Gorsuch, we're paying attention. Right, so Gorsuch did not join that one, we'll see what happens there, okay? So, as you can tell, the Second Amendment plays almost no role in modern day debates about gun control. Jason will probably agree on this in large measure. The courts have, with very few exceptions, I mean like 2 or 3, upheld every single gun law, every federal gun law, and virtually every state gun law they've come across. They just don't strike any down. We had one decision from the District of Columbia where the court struck down their carry law. D.C. wisely did not seek certiorari. That's one of the outliers. So, with the exception of maybe 2 or 3 major outliers, all these laws have been upheld. So then, why are we even talking about the Second Amendment, right? The lower courts have basically said, okay, we're going to pretend this doesn't exist, and the Supreme Court said we're going to pretend it doesn't exist. So maybe, if Trump puts 5 more justices in the court, we'll get some teeth in it, but where we are today, it just doesn't make any sense. Which brings me to Justice Stevens. right? Justice John Paul Stevens, which Professor Taylor mentioned a few moments ago. And if there's any way to be counterproductive, man, he did it. So a couple of years ago, Justice Stevens wrote a book called 6 Amendments. You ever see the movie Mean Girls, the Burn book? This is his Burn book, okay? These are all the cases where he was on the dissenting end, and he wants to amend the Constitution so its dissents become majority opinions. Good for you, Justice Stevens, right? One of his amendments would have changed the Second Amendment to say the right to bear arms, I'm paraphrasing, only exists in the militia service, right? Basically limit the right to bear arms only for militia service. Even if he did that, right, it wouldn't change a thing. Because every state in the Constitution, except Illinois, I think, has a right to bear arms provision in the state constitution. States have laws protecting gun rights, as do federal laws. What Justice Stevens actually meant was not only repeal the Second Amendment, but also create a federal law that preempts all state law and makes it a federal crime to possess a handgun. And he said it was very sloppy, so we need to take away semi-automatic weapons. Now, semi-automatic means any gun that doesn't go revolving, right? It's not a revolver. Almost all handguns are semi-automatic weapons. So his op-ed called for basically the banning of 90-something% of weapons in use today. Is that going to happen? Of course it's not going to happen, right? How do you amend the Constitution? You have to have 2/3 of both houses and 3/4 of the states. Congress couldn't even pass a background check bill. You think they're going to ban and repeal the Second Amendment? This is nuts. It's lunacy. But I want to discuss why Justice Stevens' op-ed is very significant. Okay? A common fear in the gun control debate is that the other side is not playing fair. That they may be talking about common sense and reasonable, but down the road they want to be like Australia. They want to be like England. And their ultimate goal is confiscation. And they say, Josh, you're some sort of NRA conspiracy theorist. Well, Justice Stevens proved my point. And Justice Stevens is not alone. Over the last couple of decades, people in the Gun Rights Act community, gun control community have been very active. For example, one, Pete Shields, who founded the progenitor of the Brady Center, said, quote, "We're going to have to take this one step at a time. Our ultimate goal, total control of all guns, is going to take time. The final problem is to make the possession of all handguns totally legal." Okay? Another board member of the handgun control group said, "We have to do away with guns." Okay? But they recognize it can't be done right away. I want to read you a quote from Charles Krauthammer. Now, you may know Charles Krauthammer. He's a conservative pundit on Fox News all the time, but he's not guns. And he said this some years ago. He said, quote, let me read this to you. "Ultimately, a civilized society must disarm its citizenry. It is to have a modicum of domestic tranquility of the kind enjoyed in sister democracies like Canada and Great Britain. Given the frontier history and individualistic ideology of the United States, however, this will not come easily. It certainly cannot be done radically. It will probably take 1, maybe 2 generations. It might be 50 years before the United States gets to where Britain is today. Passing a law, like the assault weapons ban," he said, "is symbolic. Purely symbolic. It's a move in the direction of what Great Britain is," he says. "Its only real justification is not to reduce crime, but to desensitize the public to the regulation of weapons in preparation for their ultimate confiscation. Its purpose is to spark debate, highlight the issue, make the case that the arms race between criminals and citizens is as dangerous as it is pointless." He wrote, "De-escalation begins with a change in mentality, and that change in mentality starts with the symbolic yielding of certain types of weapons. The real step, like the banning of handguns, will never occur unless this first one is taken, and even then not for decades." Now, I think Krauthammer says what a lot of people actually think, right? If you ever want to say Australia and Great Britain, that's basically what they're talking about. Now, I think there are people of good faith on both sides of the gun control debate, but how do you negotiate when you think the other side may ultimately go for unilateral disarmament? And this is why I think the gun debate is so dangerous, right? The way to change this or modify it is with a cultural change, that people just don't want this anymore. But simply saying, trust us, we'll stop with this law and go no further, it's hard to. Now, I want to make a broader point, and this may solidify this issue. And we're in Texas here, so it's going to be very appropriate. So, gun control activists and pro-life activists share little in common, except for their tactics, right? Gun control activists seek the elimination of as many guns as possible, and pro-life advocates seek the elimination of as many abortions as possible. Now, for the gun control activists, their agenda is hampered because the majority of Americans support gun rights. And pro-life agenda is hampered because the majority of Americans support abortion rights. Gun right activists seek to overturn Heller and McDonald, Justice Stevens for one, and pro-life activists seek to overturn Roe and Planned Parenthood versus Casey and Women's Health versus Hellerstein, the Texas case. Right? They know they can't do that now. But in the meantime, they share a similar objective. Push the boundaries of whatever legal barriers exist to stigmatize, marginalize, and frustrate the right that they oppose. A few examples. Gun controllers seek to prohibit so-called assault weapons, even those military-grade guns are owned by tens of millions of Americans, and only a handful have been used in incidents of mass violence. The true target is handguns, which are responsible for 90% of gun deaths. But they know that goal is unattainable, for now at least. Pro-lifers seek to impose restrictions on abortion that could have only a marginal effect on safety, so it's in Texas, such as a requirement that facilities do not perform abortions unless they meet surgical standards, even if they don't perform surgery. Their true target is to make the overwhelming majority of abortion demand illegal, but they know that such a goal is unattainable, for now at least. Only through a long, grueling, sustained effort of guerrilla lawfare do both groups hope to achieve their ultimate goals. Both groups cite the most egregious examples of abuse to inflame the passions and to justify these regulations. Nicholas Cruz in Florida and Kermit Gosnell in Philadelphia are the utter exceptions and not the basis for any rule. Judges of the bench, depending on their philosophical disposition, accept either of these tasks. Let me show you why. In D.C. v. Heller, Justice Breyer's dissenting opinion offered an almost obsequious level of deference to the government's desire to prohibit handguns, even though D.C. had one of the highest homicide rates in the country, and guns are readily available across the Potomac. Yet Justice Breyer exhibited the most rigorous scrutiny imaginable to invalidate a Texas law that regulated the width of hallways in abortion clinics, finding that it imposed an undue burden on women's access to abortion. I'll put aside for a moment the fact that footnote 4 of Caroline Products says enumerated rights are given more protection than unenumerated rights, and the Second Amendment is enumerated. Meanwhile, in Heller, Justice Thomas was downright skeptical of the district's interest in gun control, but in Women's Health, he accepted Texas's most speculative defenses of why it needed its abortion law. Recognizing the tactics of both groups and how the courts apply competing scrutinies and flip-flop based on the nature of this favored right should be disquieting. Guerrilla lawfare to push legislation that will do little to address the underlying problem is an emotional technique to advance us on the road to prohibition. Thank you very much.
All right, Mr. Steed, you're going to tell us every way that he was wrong in that presentation. Right?
Yes, I'm a leftist gun grabber, and I think we should ban all guns. I don't really. I'm not going to stand at the lectern because that, for me, feels a little bit too much like oral argument, and I don't want to.
Hey, please support me.
And I also don't have a formal presentation to the extent that Josh had. So I just have some more informal thoughts. And this was styled as a debate, but Josh is right. There's not. I don't think there's a whole lot that we disagree on here necessarily. I do disagree with some of the tone, maybe, of some of what Josh was saying, or some of the assumptions being made about the other side. But I think I agree with a lot of what Josh is saying. What I would want to start out by saying is I think it's important to zoom out from this gun issue and realize that the gun issue, in a sort of philosophical, ideological kind of way, is one of those issues where people on the left and people on the right can be on either side of the gun issue, from principled positions on either the left or the right. And what I mean by that is, if you go back 30, Adam Winkler's book is really good about going through this history. If you go back 30 or 40 years ago, in the 60s and 70s, the real push for individual gun rights and a more expansive view of the Second Amendment came from the left. Individuals, Black Panther Party and other people on the left, who wanted communities that were oppressed or in an unequal position of power to have a right to guns to defend themselves against the police and other things going on like that. And the gun control movement came a lot from the right. Governor Reagan in California, who was very much promoting gun restrictions to keep guns out of the hands of certain communities. And you can have that principled position for the right on the side of restricting guns and from the left on the side of protecting gun rights. It just depends on which principles you're emphasizing from the right or the left, because it didn't take more than a decade or so for that to sort of flip, and people on the right started embracing other right-leaning principles, and people on the left started embracing other left-leaning principles, and you ended up with a flip in the position on the gun issue, where it was mostly the left from a sort of collective public health, public safety kind of interest, wanting to restrict guns, and the people on the right from sort of individual liberty, some of those groups that have dreams of insurrection and secession, wanting to fight off the tyrannical federal government, and so suddenly it's the right that wants to push the individual gun rights, and it's the left that wants to restrict and have some safety laws. So I think it's important just to recognize that you can be on the right or the left and have a principled position on either side of the gun issue. And you may find friends on your side of the gun issue who are on the other side of the ideological spectrum. So I think that's worth pointing out and recognizing. I agree with a lot of what Josh was saying at the end. In fact, I had jotted a note to myself to bring this up, and then he brought it up for me. But some of the extremists on the gun control side are not that different from some of the extremists on the abortion control side, and that they do have some similar goals and similar tactics. And I was also going to note Justice Thomas's not explicit, but certainly implicit contradiction on how he's so interested in giving some real power to those Second Amendment rights, but less interested in striking down laws that are really cosmetic for abortion regulations. What I want to say, all the laws, Josh expressed some concerns about all the laws that are being upheld, and sort of indicated that maybe the Second Amendment just doesn't mean anything if we're just going to uphold all these laws and restrictions, and sort of asking whether the Second Amendment plays any role in these kinds of cases, suggesting it doesn't, since these laws are being upheld. I do sort of disagree with at least the tone of that, if not the substance, because I think the Second Amendment absolutely plays a role in all those cases. It absolutely plays a role in those restrictions. And the reason that those restrictions aren't being stricken down is because under the explicit language of Heller, I think every single one of those restrictions is absolutely constitutional under the Second Amendment. We can go through the language of Heller. Go read Justice Scalia's majority opinion, and under the explicit language of Heller, here are all the restrictions on guns that are constitutional under the Second Amendment. We can explicitly ban private paramilitary organizations. So if Idaho decides that those guys up in the woods in the northern part of the state who are organizing for target practice, and they've got their little militia that they've got a name for, and if the state of Idaho says, look, no more paramilitary neo-Nazi organizations, guys, they can legally ban those militias outright, and Justice Scalia in Heller says that's okay. You can restrict or even ban, quote, those weapons not typically possessed by law-abiding citizens for lawful purposes. And in another place it talks about weapons in common use, right? Under the explicit language of Heller, it's okay to restrict or even ban uncommon arms. And I think even though there may be millions of people who own quote-unquote assault rifles, in a country of 300 million, I think you have a pretty good argument that even if there are a few million people who own those guns, the vast majority of those guns are owned in multiples by the same people, and the overwhelming majority of the country doesn't own or use those guns. So you could say those aren't guns in common use, right? It may be okay to ban them, and in fact, in Heller, there's even a reference to assault weapons and how you may have a ban on that, and it might not offend the Second Amendment. So under the explicit terms of Heller, this is okay, right? Restrictions on dangerous and unusual weapons. Again, you might put assault weapons under that, or other kinds of weapons. Prohibiting concealed carry, restricting firearms for felons or for mentally ill, restricting firearms in quote-unquote sensitive places, so gun-free zones in schools, government buildings, stuff like that. Restrictions, or I think in the language of Heller, it's conditions or qualifications on the commercial sale of guns. That's okay. And restrictions on handguns, even, is referenced in Heller as potentially being okay. Even commonly used guns, in other words, because handguns are the most, Josh is right, that's the most commonly owned gun. But Heller explicitly suggests you might have certain restrictions on handguns and still be okay under the Second Amendment. This is all Justice Scalia's opinion. This is not inference. It's not, I'm trying to construe the opinion in a way that works for me. It's explicitly stated in the Heller opinion by Justice Scalia. These kinds of restrictions might be just fine. And they drop footnote 26. He says, our list of permissible restrictions does not purport to be exhaustive. In other words, they explicitly say in the majority opinion, there might be a whole bunch of other restrictions out there that we just haven't named yet that would be perfectly fine under the Second Amendment. This is why we can get a bunch of decisions from federal courts of appeals saying, yeah, we don't have a problem with these restrictions. And the Supreme Court can't get 4 justices together to grant cert in those cases because they all recognize under Heller, these restrictions are probably okay under the Second Amendment. So Justice Thomas is not unusually a bit of an anomaly in crying out from the wilderness that, hey, we should be doing something about this. I mean, it's not unlike, Justice Breyer saying, hey, Eighth Amendment death penalty problems, right? You just don't have 4 justices yet who are willing to say, we need to take this case and do something different. And I think, and I don't know if Josh would agree with me on this, I don't think the Supreme Court's likely to take a gun case anytime soon unless I think if it's the perfect case that allows them to actually uphold a gun restriction. I think that might be the case that they take, because I think there's so much fervor on the right and misinterpretation of Heller, thinking you have the NRA crowd who thinks the Second Amendment means there can be no restrictions on guns anywhere, and any restriction is the slippery slope to taking away everything. And a lot of misconstruing of what the Heller decision says, because I think the NRA and others on the right want to construe Heller as protecting guns against all restrictions. There's so much fervor on that side, and there's so much popular support for reasonable gun restrictions on the other side, that I think if the court were to take any gun case anytime soon, it's probably going to be that perfect case that will enable them to uphold the restriction on guns, to sort of remind everybody, hey, Heller actually allows a lot of this kind of stuff, and placate the gun safety side by saying, look, we are willing to uphold the right kind of law in the right kind of situation. That's the kind of case I think that the Supreme Court will take if they take one anytime soon. Not a case that's going to be in any of these other cases Josh mentioned where they would need to strike down a restriction in the name of protecting the Second Amendment. I don't think that they'll do that anytime soon, particularly because of the climate that we're in right now, school shootings and things like that. And a big reason for that, I mean, this is worth pointing out too. I jotted this down because I think it's really important. The law, we like to think that the law exists in a theoretical vacuum where the law is just the law, and this is just the right or wrong view of what the law is, and it's not influenced by public opinion or changes in politics and history and culture and all that. But a Fox News poll, which maybe there are some people who are going to dismiss that as liberal bias in the media, but I'm hoping not. A Fox News poll says 91% of people support universal background check law. 91%. So the liberal media is telling you people support these laws. And here's some others. 84% support requiring mental health checks. 72% support raising the legal age for purchasing to 21. 72%. 60, this is a big one. Fox News, 60% support banning assault weapons, assault rifles. 60%, according to Fox News. This is why I think the conservative Supreme Court that we have is not going to eagerly pull up cases in the middle of, in the wake of school shootings and say, yeah, it's okay to strike down any state level efforts to restrict guns. As long as it's a reasonable thing that's mentioned explicitly in Heller, they're not going to take that case and say, you can't restrict guns in that way. Not when you have this kind of popular support for just basic restrictions. And one point real quick on the assault weapons. I see this a lot. A lot of people complain about the cosmetic nature of what turns a rifle into an assault rifle. That's true. I mean, that's right. So-called assault rifles are really just regular rifles dressed up to look like something that we're going to call an assault rifle. But I'm gonna disagree a little bit with the idea that it's just for the fields to pass a law that bans an assault rifle. The 17-year-old kid who wants to get a rifle to shoot up his school, there's a reason that that's the rifle they buy and not just like a deer hunting rifle or something like that. It's been called by people gun porn. The same 17-year-old kid who really likes the hot model who's been airbrushed and dressed up and has makeup and her hair all done up, likes that better than the candid photo of the model in sweats and Uggs and no makeup getting out of her car. The reason the 17-year-old likes the one picture better than the other is because of appearance. And it's the same 17-year-old kid who's going to go buy the assault rifle and not the deer hunting rifle that's the same thing but just isn't all dressed up. So I'm perfectly okay with banning the cosmetics if that's the gun that the kid wants to go buy to shoot up his school. And it's not just for the fields, it's because I think it has a real-world impact on what guns get purchased by people who have crazy ideas like that. So that's okay with me, and under Heller, it's okay under the Second Amendment, too. So I think we can do that. The kinds of things that the gun safety people after Parkland have been pushing for are all of these same things that Fox News tells us people support. The things that they've been pushing for are a ban on assault weapons, which, by the way, we had for a while, and nobody had too much of a problem with it. And then it expired, and then politics had changed, and we can't get it repassed again. Banning accessories that simulate automatic weapons like bump stocks and high-capacity magazines. That's another thing they've pushed for. Again, that's perfectly okay under Heller, under explicit language under Heller. Universal background checks, a searchable or accessible gun sale database, mental health checks, allowing gun violence research. I think this is actually hugely important. Like, right now, government agencies are prevented from conducting research into gun violence to gather data. One of the big things that used to be a critique from the right against the left back in the 60s was that the left was just doing all this crazy ideological stuff, and the right's critique was let's be rational and reasonable, let's use data, let's use empirical evidence. Before we enact programs and policies and legislation and stuff, let's base this in like empirical, data-driven kind of rational decision-making. That was the right's critique against the left in the 60s. Today, instead of allowing rational, empirical-driven, data-based policy and program-making, it's the right that's preventing the government from doing any research to gather any data and use that in enacting reasonable, sensible gun regulations. So I think it's hugely important to let the government do that. Let's get that research. Let's get the data. If we have evidence-based information about this, then maybe we can figure out what kinds of policies or programs might help protect safety while also preserving liberty to have guns. And I do think it's worth pointing that out too, that I don't think that there are a lot of people. Josh can cherry pick a few quotes from a few people on the extreme end who want to ban all guns. Sure, they're out there. I bet if I did the research, I could find a handful of people out there who've probably got some quotes saying, you know, we ought to have complete unfettered weapons of all kinds. Please give me a tank and you know, go away so I can form my militia. I think the vast majority of us, like 99% of us, live in the middle, where we all sort of agree, yeah, you've got a right to have some guns, but also we can restrict that in some ways, right? We can have some regulations about how we buy and sell this stuff. We can have some qualifications for who gets this stuff. And really the whole fight between the two sides is just where are we drawing the line? We want people to have guns. That's a right, it's protected. But we don't want everybody to have them, right? There's some people who maybe shouldn't. And so just where we draw the line is all we're fighting over. Why not enable government agencies to do research and have data and information that enables us to find where the best place to draw that line is in whatever given policy we're debating over? So I think that's a really important thing. Obviously, that doesn't violate the Second Amendment to allow the government to do that research and gather that kind of data. Another thing that's been pushed for is raising the purchase age to 21, which we've already talked about. Josh has got I can't remember if it's an article or a blog post, but something about how enacting that kind of policy may cause problems for state law, which I think is probably true. But you could pass a federal law. Josh cast this as something to be afraid of. A federal law that would preempt all the state laws. Okay, I'm okay with it. If you had a federal law that said you can't purchase a gun until you're 21, that's perfectly okay under Heller. And if we decided democratically as a community nationwide that would be a policy that would promote collective public health and public safety, it's not a problem under the Second Amendment. It's just not. And so it's just a matter of democratically deciding whether we think that's a good idea or not. And then another one another policy that's been promoted is increasing school security. That's, I don't think we need necessarily get into that, whether we have increased armed patrols of schools or, God forbid, giving teachers guns and stuff like that. As a policy matter, I don't think personally that there may be some of those things that are a good idea. I don't think I'm going to go on record saying giving teachers guns, not a good idea. Let's not arm all the teachers. But I don't think that that's the policy thing we need to get into really today, because I don't think that has anything to do with the Second Amendment. Those are policies about giving more people guns, which I don't think anyone on the Second Amendment, the pro-Second Amendment side, is going to complain about. Hey, don't violate the Second Amendment by arming our teachers, right? And clearly they're okay with it. But so that's a policy I think is different. But one of the things that I think is interesting, and I wanted to mention this, is and Josh, I think, touched on this a little bit. The overwhelming majority of people who own guns own handguns, and it's also true that the overwhelming number of deaths caused by guns are caused by handguns. About 21,000 people every year. 21,000 people. I live up in Prosper. That's the population of Prosper. Okay? Every year, the population of Prosper kills themselves with a handgun. That's a problem that we have in our country. I think it's perfectly legitimate for us as a collective group, through a government that we use as a tool, as a collective group, to do things that we think collectively are a good idea. I think it's appropriate to try to find ways to address that problem. It crosses over into the mental health issue, but it also crosses over into the access to guns, because the studies will all show that a large percentage of the people who commit suicide with a gun wouldn't have if they didn't have easy access to that gun. It's because they had easy access to the gun that they went through with what they did. And there are lots of studies that will show even a delay of several hours or a delay of 24 hours in their ability to get that gun that moment where they're ready to kill themselves often passes, and they don't, because they didn't have the means to do it immediately. So coming up with policies, potentially, that might help in that area, I think that's a good idea. I think that's something that we should try to do. And we ought to have the data and the evidence that helps us figure out how to do that. And I don't think that that causes any problem for the Second Amendment. The other thing too is Josh brought up I'm getting into my notes about what Josh was saying.
How much time do you look for it?
We got like about 7 minutes left, so if you can wrap up in like 2 minutes.
Yeah,
I want to reserve at least 5 minutes for questions. I'm going to dispense with all.
I'm going to waive my rebuttal because we all want to go to Q&A.
The last thing that I'll say too is just in reference to the rights and Josh asking at the beginning, like why the Second Amendment should be treated any differently. I don't think it is. I don't think it's treated differently. I mean, maybe at the margins there's some kind of difference or something, but the idea that Josh mentioned all the other amendments, the First Amendment, Fourth Amendment. They all have social costs to them, like the Second Amendment. Why does the Second Amendment social cost mean that it gets treated differently? I don't think it does. The social costs from the First Amendment, the Fourth Amendment, the Eighth Amendment, they're addressed in our constitutional law because there are limits on those rights in situations where those rights create social costs. So the reason that you don't have the First Amendment right to say certain things like inciting violence or whatever, it's because we've said, look, there's some social costs to that First Amendment right that create limits on that right. Same thing with the Second Amendment, right? We have the right, but there are social costs that come with it, and that means that we're going to have to put some limits on that right, just like every other right. I don't think that's different from all the other rights. I think that's pretty much the same as all the other rights. We don't have any right that I'm aware of that's just so absolute that nothing can be done to limit it. So that's all I'll say, and
I'll leave it, but let's go to Q&A.
Yeah, so I'm going to waive all my questions unless we don't have questions from the audience, but we do, so go ahead.
Say we live under Stephen's world, and in 10 years we find ourselves in a country where we've repealed the Second Amendment, and it just says that a well-regulated militia is being necessary to secure a free state, and usually that half, and then there's, of course, the federal law you propose that says no citizen can purchase a gun. Texas, being a free state and wanting to secure it with a well-regulated militia, say they open up they open up registration to a militia, and any Texan can go up to a state office and register for the militia, and he gets a permit, and as a member of the militia, he can own a gun. Would that be constitutionally problematic in that world?
So actually, some states have tried this indirectly. What some states have done is they've allowed anyone to apply for what's called a deputy license. And most states allow you to carry anywhere you want if you're in law enforcement. So some states have tried, basically, if anyone wants basically a badge, they can go carry in California. I don't know how those laws have fared. But your question is basically taking hell of a sense, saying that the federal government can't interfere with the state militia. I suppose Texas could just enlist everyone in the militia and allow them to bear arms in any state. Think about that.
I think it depends on what you mean by repeal the Second Amendment. I mean, you framed it as repealing the Second Amendment, but leaving the militia part at the beginning.
Well, yeah,
that's part of the Second Amendment.
Right? What Stevens had proposed, right?
Yeah, I mean, if you leave the militia part, then you might not have a problem there. If it's okay to have a gun when you're part of the militia and the state creates a militia, I mean, maybe constitutionally you don't have a problem. I think if you repeal the Second Amendment entirely, so it just doesn't exist, and then you pass a federal law banning all guns, then I think states don't. I'm not sure how states get around that, but I don't know. I mean, that's kind of purely hypothetical.
What's going on?
So if obviously I think we agree that the Fifth Circuit and the Ninth Circuit are going to rule differently on gun issues.
Well, not really.
The law is the law.
No, unfortunately, I've lost Second Amendment case in the Fifth Circuit. We lose here also.
I think my question really is, do you think that the Supreme Court doesn't want to rule on these new gun related issues because they just want to keep the status quo? Obviously, there's certain geographic and cultural changes that are different across the country.
They're not. Gun cases lose in every circuit. I think 3 Fifth Circuit panels have ruled in the Second Amendment. But let me answer your broader question. there are two ways of looking at this. Perhaps the justices say, if we take a Second Amendment case, it might be worse or it might be better. And I think until Justice Kent leaves the court, we don't really know which direction that's going to be. Yeah.
Mr. Steed, I remember you, the way you kind of cited your argument, it's almost as if like the Fourth Circuit in their most recent review, Heller 2, I think it was, used that exact same framework to kind of operate a holding of a certain gun restriction. But I think section 4 of Heller 1 under Scalia, he calls the handgun the quintessential defense weapon of the home. And isn't and just that distinction between the classification of weapons, we talk about assault weapons, we talk about handguns. It almost seems like that's been elevated to a particular right of everyone has a right to a handgun in the home specifically. Would you agree with that reading?
I think one of the contradictory parts of Justice Scalia's opinion is that he does elevate the handgun as the most commonly owned gun, and that's why it can't be restricted, and then later says even restrictions on handguns might be okay.
Right.
So, do I think that you have an absolute right to a handgun in the home? I'm not sure, because according to Justice Scalia himself, I'm not sure.
Let's do one more question, if we have one, please. We've exhausted our... All right, one more.
If I could ask the panel about the distinctions between limitations on the Second Amendment versus other amendments, and whether you think that the Second Amendment involving weapons from the outset would require a different kind of limitation when we talk about the danger or the social cost.
Well, my framework is all about burdens. Generally, when the government wants to deprive a person of a burden, of a right, the burden's on the state to make that deprivation. Right? This is, about scrutiny, right? In constitutional law, you have a strict scrutiny standard. The state bears the burden. And if you go to the Bill of Rights, this is what Carolyn Pratt teaches, the burden's on the state. In every single Second Amendment case where the plaintiffs have lost, the courts have put the burden on the plaintiffs. This is what we call almost a rational basis review. Now, Heller said, we're not doing rational basis. Call it intermediate, call it whatever you want. It's basically putting the burden on the individual. And that much, I think, is improper. If the government can actually deduce evidence of why this regulation is needed, that's fine. But if you put the burden on the plaintiff to disprove every possible reason against it, the plaintiff's going to lose it every single time. Fifth Circuit, Ninth Circuit, I don't care where you are. So that, I think, is where the Second Amendment has been treated differently than its brethren in the Bill of Rights.
And I think that's right. Like, I agree with Josh on the burden part of it. In the more general sense that the right's been treated differently as far as having limits on it, I don't think that's any different. But the burden is right. I would sort of tangentially off of what you're asking about. Like, what I would really love to see is open up guns to tort liability. Seriously, product liability. There's a lot of products out there that have been ruled inherently dangerous, and you're not going to necessarily, but you may face liability if that product gets misused in a way and someone ends up hurt or dead. Open that up. Let's see how that plays out as a way to self-regulate. Companies regulate themselves out of fear of tort liability, right? They try to do things to avoid tort liability because that's the only ways we have to make people do things safer is preemptive regulations and, pre-hoc, I guess, was that what it, what's
Post-hoc.
Post-hoc is after. What's the pre?
Ex ante.
Ex ante, okay, yeah.
So,
right, so you can either regulate it ahead of time, try to impose regulations ahead of time, or you can sue afterwards, right? Those are your only ways to get people to act in a more safe way. So, you guys if you don't like restrictions on guns on the front end, allow some tort liability on the back end, at least, for when somebody misuses, or if someone's grossly negligent, leaves a gun out, 4-year-old kills their 6-year-old sibling. Why is that not open to potential tort liability, right? So, if you want to take away both, then you're part of the problem. If you want to help solve some of the problems, allow something to happen, either on the restriction side or on the tort liability side. I'd love to see a Second Amendment challenge to a law that provides for a civil tort action for gun.
I got one. A school that doesn't properly defend itself, can you sue the school for failing to defend it from children?
I'd like to see the lawsuit. I would like to see what happens, how do we do that? What I'd like to see too is the lawsuit about qualified immunity where the teacher kills the student they thought might have been reaching for a gun. And now the teacher gets qualified immunity for shooting the student.
Well, call me crazy. I don't want to see that lawsuit because I don't want to see that happen. But we're out of
Arm the teachers, it will happen.
well, we're out of time. But let's thank our panelists.